cordially welcome our chief guest for today, Honorable Advocate Amarjitsingh Girase sir, Government Pleader at High Court of Bombay, bench at Aurangabad. As it is a tradition of our college of opening any program with the recitation of preamble, I would now like to do the same. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Jai Hind. I now request our coordinator, Dr. Abhay Jadhav sir, to introduce today's program. Over to you, sir.
Thank you, Mihir. Let me wish we all 30th Naam Vistar Din. On this auspicious day, today we have with us Chief Guest Advocate Amarjitsingh Girase sir, who is the government leader at High Court of Bombay, bench at Aurangabad. So I, on behalf of Marathwada Legal and General Education Society and its Manikchand Pahade Law College, welcome you, sir. We know that on this auspicious day, way back in 1994, 30 years back, this university got the name of Dr. Babasaheb Ambedkar. For giving this name of Dr. Babasaheb Ambedkar, there was a long people fought for having name of Dr. Babasaheb Ambedkar. This movement has been there for around 18 years. And finally, in the year 1994, this university, which was earlier known as the Marathwada University, was renamed and was extended with the name of Dr. Babasaheb Ambedkar. So from there, in our college, every year, we celebrate this day by inviting the scholars. The very purpose behind organizing this special lecture is that we want to make students aware about the multidimensional person of Dr. Babasaheb Ambedkar, who is known for many. He has very good qualities, and every year on this occasion, we try to invite the scholars, speakers who will talk about the specific qualities of Dr. Babasaheb Ambedkar. To mention few earlier, we have invited and people delivered the lectures on the Dr. Babasaheb Ambedkar and journalism, Dr. Babasaheb Ambedkar and human right approach. Like this, we conducted several programs. This year, we thought that being students of law, how Dr. Babasaheb Ambedkar contributed judicially. What was his judicial contribution? With this objective, we decided to invite Advocate Amarjitsingh Girase sir. So hence we called him, we invited him, he immediately accepted our invitation. For this, I'm extending the sincere thanks on behalf of our college. So I know that you all are very eager to listen Advocate Amarjitsingh Girase sir. So I won't be there. Just I would like to conclude my introduction that so on this day we will take that whatever we will learn throughout this lecture, we will try to implement in our daily society. This I stop. Over to you, me.
Thank you, sir. I now request, without any further ado, our chief guest, respected Advocate Girase sir, to kindly take the charge. Over to you, sir.
Respected Principal, Dr. Rao sir, the Vice Principal Sri Shri Krishna Moreji, the coordinator of today's lecture, Abhijit Jadhav, Mihirji and all students and the faculty members of the MP Law College. A very good morning to all of you. Today, we are celebrating the name expansion day of Dr. Babasaheb Ambedkar Marathwada University on 14 Jan 2023. Today, we are also celebrating 100 years of completion of the practice of Dr. Babasaheb Ambedkar. When he started enroll as a lawyer and started a practice, we are celebrating 100 years of that day. On this issue, when we are saying that the judicial contribution of Dr. Babasaheb Ambedkar, Dr. Babasaheb Ambedkar, popularly known as the father of the Indian Constitution, was a social reformer and crusader against the caste system. When we celebrate this 100 years, we must also remember him as a lawyer of the marginalized and voice of the voiceless. Dr. Ambedkar's interaction with the law was at multiple levels. As a practicing lawyer, as a professor of law, as a legislator, as a policy maker, as a framer of the Constitution, and as a social reformer. He practiced at the district courts, court of princely states, high courts, and the Supreme Court. He was a professor of law at Government Law College, Bombay, and thereafter its principal. He was a member of the Legislative Assembly in the Bombay Presidency. He was a labor minister in the Viceroy Executive Council and the first Union Law Minister of the independent India. He was a chairman, we all aware that. He's a chairman of the drafting committee of the Constituent Assembly. He led many social movements and struggles for the emulation of Dalits and the working class. In his multiple writings, he conceptualized the purpose and the role of law in human life and society. Born on 14th April 1891 in an untouchable family, completed his schooling at Satara in Maharashtra and then attended Mumbai Elphinstone High School. Then he completed his MA and PhD in Columbia University, United States, MSc and DSc in the London School of Economics at Britain, and then he spent 2 periods of study at Grey Inns in London before being called to the bar by Grey Inn. After returning into India, after this acquiring higher studies, Dr. Ambedkar started his law practicing at Bombay High Court in July 1923. So we are celebrating his 100 years after starting of his practice. We are aware that he didn't have enough money to pay even the registration fee for the enrollment. His one of the friend, Mr. Naval Bhattera, came to his rescue and gave him a requisite fee of 500 for the registrations. And then he enrolled himself and started a practice. In his short span of practice, because we are aware that the lawyer must know from the judgments reported. And then when this subject came, when I started to search the reported judgments of Dr. Babasaheb Ambedkar while appearing from either this side or that side, then I find that there are 29 judgments reported at the various law journals, All India AR and from AR to All AR. Those 29 judgments, I have taken a compilation of those 29 judgments, and now we are concentrating on those few cases here. We will discuss on one by one. One of the famous cases where he appears with this judgment was reported in AR 1928, Bombay 78. This was the judgment of Emperor versus Vistar. This matter pertains to Section 14 of the Indian Evidence Act, that is the intention of the accused charges under Section 124A of IPC. This is the matter, this is one of the famous cases wherein Dr. Babasaheb Ambedkar appeared as a counsel, assisting his senior with defense of Philip Spratt. Philip Spratt is a British communist on whom a charge were leveled for causing hatred towards the government because of his pamphlet, India and China. In this case, the argument was advanced on behalf of the defense, but which was led by Dr. Babasaheb Ambedkar, that no disaffection has been shown towards the government of India, and whatever had been said, that was refer either to the British imperialism or to the concept of imperialism in general. Thus, the same would not come within the purview of sedition. Now, we are all aware that sedition, that was an issue which was a very burning issue today, and the various judgments of the Honorable Apex Court, the issue was referred to the larger bench, reconsideration of this section. That time also that section was there, and that this issue come, and this judgment was one of the famous judgment at that relevant time. And Philip Pratt finally owned the case, and this marked as the beginning of Ambedkar's era in this field of this practice. This was one of the leading matter wherein this judgment was reported in the AR 1928, Bombay 78. One of the other judgment which was reported, that is reported, this is a matter pertaining to the Trade Dispute Act 1929. That was judgment. Again, this matter was judgment was reported. A catalog of my explained as a lawyer would be incomplete without mentioning this matter as a defense of a trade union leaders for whom he stood by every hour of the crisis. Though Ambedkar did not identify with the communist leaders and their politics, he still defended them in a courts of law. There are very popular union leaders, P.B. Karmik, Maniben Kara, B.T. Randive, and Abdul Majid. And when he is appearing as a defense counsel there, Ambedkar succeeded in his defense and was able to demonstrate in the court the loopholes present in the Trade Dispute Act 1929 that allowed strike only for a limited purpose. This matter is also important because in this matter, the various issues come for the discussions. One of the issue is that so far as this Trade Dispute Act, the issue that which gives a power to the industrialist, and that was the issue which was under challenge, wherein just a minute, wherein this issue held that the right to liberty, right to say something, that was also an issue was under this matter. This issue, this judgment is also reported. And the next matter is a defamation. This is a known Jedhe Javalkar trial case, which is very popularly known at that time. That skills was another, this is a matter wherein the Dr. Babasaheb Ambedkar shows another demonstration of his skill as a lawyer. This is a matter wherein one article, a book was published known as Deshache Dushman, Enemies of My Country, released in the year 1926. And a defamation case was filed in this matter. The charges leveled against the author was that he defamed Bal Gangadhar Tilak and Vishnubandhu Chipulkar by calling them as enemies of the nation for their Brahmanical ideas of supremacy. Ambedkar was again successful in his defense, arguing about the locus of the petitioner, who was neither the close relative of Tilak or Shastri. Further, he argued that these eminent personalities were not alive anymore. The argument that there was no basis to find the case of a defamation by a third person was accepted by the judge. So the issue of the locus standi, now we are in so many matters. When the matter was came up before the court, we are raises the issue that what is the locus standi of the petitioner to file the petition? And this was one of the most issue. What was the defense? And the defense was taken, that is that the petitioner has no locus standi to file the present petition of defamation. And that was one of the reported judgment which was reported in AR. And that gives another feature in the basis of Dr. Babasaheb Ambedkar. The another issue which was very popularly known as when he defend, see the which says that that is a destiny. Dr. Babasaheb Ambedkar was awarded as a Bharat Ratna, and Dr. R.D. Karve, who also Maharshi Karve, we had known his popularly as a Maharshi Karve, he was also awarded as a Bharat Ratna. But when it the case when both are before independence, that time there was Samaj Swasthya. One of the famous articles were written by Dr. Karve, which was charged offensively were framed against him. And that was the issue, because we are aware that that time where now in today's era, we are also not speaking about the sex education and others thing. That time when that was a pre-independence area, it's very difficult to speak about the sex and others things. But Dr. Ambedkar defended social reformer Raghunath Dhundo Karve in an obesity case filed against him. Karve published Samaj Swasthya magazine that aimed at creating awareness about the sexual health. Despite facing severe opposition from the people due to his sensitive subject, he advocated sex education. The topic which are still spoken of in whispers today, Karve used to speak of freely in those days. And an officer who claimed to be an Oriental translator found some content in the December 1933 Gujarati edition of the magazine in the section of answers written to some correspondence to be vulgar, and the government filed case against Karve. Now, Karveji requested Dr. Babasaheb to defend the case, and Babasaheb, being a national leader, he used to he accept the case, maybe because of the supported cause of which Karve has dedicated his life, sex education and a family planning, containing his unwanted support for any progressive activist. Dr. Babasaheb Ambedkar decided to fight this case. In his argument, he brought to the notice of the court that the observation made by the Bombay High Court in case of Emperor versus Vishnu Krishna Puranik in 1912, that vulgarity does not lie in the content, but in the forms of the expression, and what is vulgar and what is not does not depend on its meaning, but in the way something is said or written. He marshaled the extensive argument about the meaning of vulgarity, and then the said matter was owned by Dr. Babasaheb Ambedkar. These are the few examples Babasaheb Ambedkar appears in the matters. Recently, the Supreme Court of India published one article, and on the on the website of the Honorable Apex Court, there are the list of the judgments which were published in the All India Reporters. There are more than 29 judgments wherein Dr. Babasaheb Ambedkar appears. Just if we just peruse that list and the matters wherein Dr. Babasaheb Ambedkar and the sections concerned, I will give cursorily one by one. The first is published in the year AR 1926, Bombay 314. That is Yashwant Sattva Chaugule versus the Emperor. This is a matter pertaining to the section 225 of the Criminal Procedure Code, and omission to state common object of unlawful assembly in a charge is not a fatal, where common object of an unlawful assembly is specified in the complaint and found by the court, then its omission in the charge does not vitiate. This was the first judgment wherein the Calcutta High Court judgments was referred, and that was the first matter which was published in the year 1926. The another is Ahmedabad Cotton Company versus by Budhan Rajaram. That was an original judgment. This was published in the year 1927, Bombay 223. This is a matter pertains to the Workman Compensation Act, and where Section 3, that death of workman caused through its act, which was incidental to his work, his act was held to arise out of it and its course of his employment, and held that that act of the deceased workman in removing the hazel cloth was incidental to his work and was done in the performance of his duty and arose out of it in the course of his employment within Section 3. and the compensation was awarded. The another case was Emperor versus Shantaram Miratkar. This was published in the year 1928, Bombay Law Reporter 320. This is a matter pertaining to the section 239 of the Criminal Procedure Code. It's a joint trial printer and publisher of an early sedition pamphlet that we have referred. The printer and the publisher, a pamphlet alleged to be seditious, can properly be tried jointly for an offense punishable under section 124A of the Indian Penal Code 1860. The Advocate General also appeared in that matter. That was one of the reported judgment. Then it's AR 1928, Bombay 77, Emperor versus Philip Stott. We have just discussed this matter. There are two judgments, AR 1928, Bombay 77 and AR 19 Bombay 78, sorry. Both are pertaining to the one is pertaining to the Evidence Act section 14, another is Evidence Act section 9 and 14. That is the admissibility of the copy of letter written by accused as an evidence when the original one was not forthcoming. And it was held that the copy of the letter was relevant to show the accused's intention and could be admitted as evidence. And it is not necessary for the prosecution to prove that such a letter was sent before the copy could be admitted as an evidence. These are the two judgments which we have read, that article written by that Philip Stott, and both were owned by Dr. Babasaheb Ambedkar. One another is the Nana Khandera Khadge versus the Emperor. This was published in their AR 1927, Bombay 647. This matter pertains to the section 194(5) of the Code of Criminal Procedure. Court has a power to sanction prosecution for an offense before commission appointed by it. The commissioner is subordinate to the court appointing him, and the offense to refuse to take the oath and answer the question put by the commissioner is an offense against the court itself. That was held by the court, and that was the matter wherein Dr. Babasaheb Ambedkar was appeared for the applicant. The another judgment is Emperor versus Vithabai Shukla and others. This was published in their AR 1928, Bombay 336. This would pertain to the section 373 and 372 of the Indian Penal Code. Object of the possession is the test. Possession for 2 or 3 hours by the brothel keeper in the night is a sufficient possession. Bombay Prevention of the Prostitution Act 1923, section 6, brothel keeper is availing herself of the supply of the procurators of guilty of abatement. That was the matter which was wherein Dr. Babasaheb Ambedkar was appeared. One of the another judgment is the Khandesh Lakshmi Vilas Mills versus Graduate Coal Concern Jalgaon. This was published in their AR 1935, Bombay 75. This is pertaining to the section 152 of the Civil Procedure Code. Decree drawn up in terms of the interlocutory application instead of according to the final order, owing to the mistake on the part of ministerial servant who has inherent power to amend the decree. Under section 125 of the code has inherent power to vary or amend its own decree or order so as to carry out its own meaning. Hence, where a decree was apparently drawn up in the terms of the interlocutory application for a final decree by a mistake on the part of ministerial servant, but it ought to have been drawn up accordingly to the final order of the judgment himself. This is the court held that the court has an inherent power to amend the decree as per the final order, and that was one of the famous reported judgment in pertains to the Code of Civil Procedure, which was published in the year 1935, Bombay 75. Another judgment is Gulabrao Chandbude versus Emperor, that was published in the year 1935, Bombay 409. This matter pertains to the jurisdiction. Mere definition, areas cannot exclude the jurisdiction of a magistrate in the rest of district. Section 12, subclause 2 of the Criminal Procedure Code requires express or necessarily implied provisions to exclude jurisdiction. The mere definition of areas of a jurisdiction cannot be taken as a provision excluding jurisdiction of the magistrate in the rest of the district subsection 2 of section 12 of Criminal Procedure Code clearly requires some provisions excluding jurisdiction in the rest of the district, which is either expressed or must be inferred by the necessary implication. There in 1929 all 123, this is a judgment wherein Dr. Babasaheb Ambedkar appeared for the accused, which was published in the year AR 1935, Bombay 409. Another judgment referred is 1935-37, Bombay 892, wherein Dr. Babasaheb appeared for the accused. This is the Emperor versus A. Alvin. Trade Dispute Act, that's a matter, and that is matter under section 16 and 17 of the Trade Dispute Act. This matter pertains to the illegal strike and furtherance of the trade dispute within the trade, association and other dispute render strike illegal. Government, community, design or calculated. These are the words which were interpreted in this matter. And 7, general and prolonged hardship upon the community, compulsion on the government, general strike in textile industry of India. And that was hailed by the one of the famous judgment, which gives a right to the worksman declare of the term to declare as a strike as an illegal, there are the restrictions were imposed, and this is one of the famous judgment pertains to the rights of the worksman while working under the Industrial Dispute Act. Another judgment is AR 1938 Bombay 228. It's a Vithabai Dattu Pattar versus Mallar Shankar Kulkarni. This is a matter pertains to the section 108 of the Indian Evidence Act. The issue is that person not heard of or more than 7 years cannot be presumed to have died at a particular date. The Transfer of Property Act, section 43 and 6 of erroneous representation by the transferor that he is the full owner of thought, in fact entitled merely space succession, that section 43 was discussed in the matter. And that was one of the issue wherein section 108 of the Indian Evidence Act was considered along with the provisions of the Transfer of Property Act. The another judgment is published in their AR 1938 Bombay 331 is the Ramchandra Darvi versus Lakshmibai Shankarao Kalkundri. It's that time the Saranjam and Saranjamdar has no right to create a Saranjam. A Saranjam, which is a political inam, appears by its very nature to be incapable of being created except by government or the sovereign power alone. Hence, it is not possible for a Saranjamdar to create a Saranjam in favor of a stranger. That was reported, and Dr. Babasaheb Ambedkar appeared on behalf of appellant in this matter, and that was held that was a title or that was an inam given by the government, and the Saranjamdar cannot by itself gives it to the third party or stranger person without following due procedure prescribed in a law, and which is not, he is not competent to do so. That was held by the court. Then another judgment is Asman Vaman Yadav versus Ganpat Tukaram and others. This was published in the year AR 1938, Bombay 443. This is a matter pertaining to the Hindu law. Alienation issue was considered that father mortgage not for the antecedents debt does not bind son's interest even if the debt is not proved to be for immoral purpose. That was an issue. Various legal luminaries were appear in that matter. P.B. Gajendra Gadkar, Ramnath Chitral Sarvai, Sekers, and all others were appear in those matters. And this was a judgment pertaining to Hindu law and alienations and right and shares of the persons from the Hindu family. That was a discuss which was published in the year 1938, Bombay 443. The another judgment was Govind Gurunath Naik versus Dipaka Allappa Hubali. This was reported in the year 1938, Bombay 338. It's pertaining to again a Hindu law, alienation, and manager creditor making inquiry and satisfying himself that a manager is acting for a benefit of estate of family. Real existence of Ali's necessity is not condition precedent to validity of charge. what is the legal necessity and what is for the benefit of his estate depend upon the circumstances of each case. No duty is cast or creditor to inquire as to what happened to money subsequently. This is a matter pertaining to the Hindu law, alienation, father and ancestral property. Alienation is not void, but only voidable by son. He can also ratify it. That was the issue held by the court, and the further held that second mortgagee of a joint family property taking his mortgage with a notice of fact that first mortgagee was for a legal necessity, he cannot raise a question of want of legal necessity. That was held by the court. This is again a pertains to the Hindu law, which was published in the year 1938, Bombay 388. The another judgment is Muktan Das Ajab Das versus Emperor. This is a criminal trial, and wherein the issue was considered the duty of prosecution to call witness. Eyewitnesses were not numerous, but must all be examined. Evidence Act, that section 155 and section 145, that was considered that oral statement made to witness by others, question to witness about those statements are legally admissible. That was the issue that was considered by the court in respect of the criminal trial. The another two, three judgments, either Shanmukpa Gurlingpa versus Rudrappa Malli. This is against in pertains to the Hindu law published in the year AR 1939, Bombay 266, wherein the subsequent born son, alienation by sole surviving co-partner, cannot be objected to by son born to or adopted by him subsequently. This is a Hindu law. Debts, co-partners, debts incurred by the sole surviving co-partner are not binding on a son adopted in the co-partner subsequently, unless contracted for a necessary purpose for the benefit of the family. That was the issue which was considered. Then it's another judgment is AR 1939, Bombay 250. Is T.L. Wilson and Company solicitors versus Hari Ganesh Joshi and other. This matter pertains to the Contract Act, and solicitor agreeing to accept full tax cost only in the event of successor, so as to lighten burden of client in the event of failure. Agreement is valid and enforceable. That the Civil Procedure Code Order 45 Rule 7, Object and Security, solicitor can recover his tax cost by summary proceeding from amount deposited under Order 45 Rule 7. That was the issue which was considered, and wherein L.G. Khare, Y.G. Dikshit, B.N. Gokhale, and so many persons, legal luminaries were appeared in that matter. That was AR 1939, Bombay 250. The another judgment is Jivan Rao Deshpande versus Vishnu Kalwade. This is against Hindu law, religious endowments, and right of worship. Private family devastan worship and the management given to the members by annual terms, but without right to alienate. Descendants through female cannot inherit right of worship and management. That was the issue which was under consideration, and this matter was published. This judgment is published in AR 39, Bombay 207. Another is the Janardhan Govind Gore and others versus Advocate General of the Bombay. This matter, which was published in the AR 1939, Bombay 202, is matter pertains to the will, construction, my community interpretation. That is the issue when one Chitpawan subsection of the Maharashtra community is a community by itself having a peculiar characteristics by which distinguish it from the other communities, forming part of the larger Maharashtra community. And a testator, a Chitpawan Brahmin, by his will directed his executors to pay certain legacies and bequests. One of them read as a sum of rupees so and so towards a medical relief of a person of my community or any other charitable purpose of utility of my community, such object to be named after me. And it was held that the words my community refer to Chitpan Brahman Hindu community and not the other Dakshini community as a whole. That was the issue wherein for Dr. Babasaheb Ambedkar appeared for the plaintiff, and which was published here AR 1939, Bombay 202. The another 2-3 judgment is the Putalaji Vishram Desai and others versus Damodar Vishnu Vaidya. This judgment was referred in the AR 1939, Bombay 402. It's a grant of soil in alienated village of Peshwa in the year 1978. Inamdar is the owner of the trees standing on the lands already in occupation of Khos, Darikaris and permanent tenants. Adverse possession, the right of trees. Both the Darikaris and permanent tenants in alienated village openly cutting trees on their lands for more than 35 years to knowledge of Inamdar and without his permission. It was held that Inamdar claimed of tree is a bar. This is a matter wherein adverse possession issue was discussed in long and Dr. Babasaheb appeared for the appealants. This matter was reported in AR 1939, Bombay 405. The another judgment is Krishna Mahar versus Shankar Krishna Gandhi and others. This is a judgment reported in the year AR 1939, Bombay 419. This is a Deccan Agriculture Relief and Section 15D interpretation, wherein a suit for account is not maintainable if the requires setting aside the sale of equity of redemption. A suit for account of mortgage which requires the setting aside of the sale of equity of redemption is not maintainable under Section 15D of the Act. Then another judgment is Narendranji Ramesh Snehi versus Vivek Ramji Bhagat Ramji Ram Snehi. It's reported in their AR 1939, Bombay 425. This matter pertains to the Limitation Act. A limitation can be pleaded even if in appeal, Bombay Land Revenue Code, Section 133, sanad granted under Section 133 is not a document of a title. Persons suing for the possession need not set aside a sanad before obtaining possession. And Article 14 Limitation Act no bar to such a suit. That was an issue which was discussed in that judgment. Then another judgment which was reported in the year 1939, again in Bombay 526, it's a matter of Mahadev Mehta versus Khanderao Tipnis. This is a matter pertaining to the section 68 of the Code of Civil Procedure Code. Date on which status of the judgment debtor is to be considered is a date when order for sale is a pass. And order 21 rule 64 of the Civil Procedure Code, order under 21 may be modified if the judgment debtor appeals to order 21 rule 60C and prove that they are agriculturalists. So administrative directions relating to the proclamation of sale do not fall under Section 47, but order as to whether sale is to be held by court itself or by collector falls under Section 47. That was held by in that matter, wherein Dr. Babasaheb appeared for the respondent. This judgment was reported in AR 1939, Bombay 526. Another judgment is Jagannath Agarwala versus Shivanand Bhagirath and others. This was reported in AR 1940, Bombay 247. This matter pertains to the surety. Managing agent of the company standing surety for the debt due by company to its creditor. Company would up scheme under Section 153. Companies are creditor receiving half sum in cash and other half in the shape of preferential share. This held that did not discharge surety. Surety, his liability is coextensive, but not in the alternative. Joint family business to justify the manager's standing surety on the ground of legal necessity requires strong evidence, and it was held that joint family business question whether passing of letter of guarantee by manager is an ordinary incidence of business is a question of fact, and that was held by the court. And this was a matter wherein Dr. Babasaheb Ambedkar appeared along with S.G. Patwardhan, Sir Jamshedji Kanga, S. Shankar for the respond and Ramlal Shivlal for the respondents. The another judge matter is Emperor versus Seva Medical Dentist. This is a matter pertaining to the Bombay Abkari Amendments Act, Section 6, and deleting the provision of Section 14B subclause 1 of Abkari Act. Objection of deletion was stated. Bombay Abkari Amendment Section 7 is not retrospective. notification effective at the date of passing of amending act alone fall under section 7. So section 7 does not affect the notification already rescinded or declared invalid. Notification declared ultra virus by High Court falling under section 7 cannot relieve the notification. Bombay Abkari Act notification under section 14 and effect of stated provision, legislator has a right to prohibit possession of intoxicant. Its right to legislate as to possession of intoxicant must be exercised subject to right of central legislation in respect of import and export across custom frontier. This is a matter which was published in the AR 1940 Bombay 307, MC Setalwad, Advocate General, PF Tarapurwala, GN Joshi, R. Jagirdar, Jamshedji Kanga, H. Velinkar. These are the legal luminaries appear in this matter along with Dr. Babasaheb Ambedkar, either for the petitioner or the respondent. And this law was settled. There's another 3 judgments. One is Allah Datta versus Emperor. It's AR 19 reported in AR 1941, Bombay 334. That is in respect of Bombay City Police Act and Section 27 and orders under Section 27 by Commissioner is not revisable under Section 439 of the Criminal Procedure Code. That was held, and Dr. Babasaheb Ambedkar appeared in this matter on behalf of the appellant, and they own the case. The another is Emperor versus Karsandas Govindas Ved. This was AR 1942, Bombay 326. This is a matter pertains to the Bombay City Municipal Corporation Act and Section 390 of the said Act, and wherein summons to accuse issue was considered Section 390, Section 514 that was considered, and meaning of continuing offense explained. Establishing of factory without permission is an offense committed once for all when factory is established. But working of factory without permission is an offense which arises on every day on which factory is so worked. So Bombay Municipal Corporation Act Section 390, offense of working factory without permission and previous acquittal cannot under Section 403 bar subsequent charge of working factory without permission. That was a matter wherein Dr. Babasaheb appeared on behalf of the accused. This was reported in AR 1942, Bombay 326. One another judgment is Narayan Ramchandra Jarab versus another emperor. It's Section 375, Section 423 and 418. Death sentence passed by the session judge at the jury trial on a majority opinion. Appeal by accused and confirmation case before the High Court. It is not necessary to dispose of appeal before dealing with the confirmation case. Power of High Court mentioned in Section 376 are not affected by Section 418, 423, and High Court is bound to consider all questions of law and fact that was held. Dr. Babasaheb Ambedkar appeared for, and Mr. V.R. Gadkari appeared for the accused, and one Mr. L.G. Patwardhan appeared as a government pleader on behalf of Crown. This was AR 1942 Bombay 244. And the another large judgment is, this was after the independence, it's AR 1948 Bombay 244. And the last judgment which was reported, that was in the Supreme Court, and that was AR 1953 Supreme Court 179. This is a matter of Mahadev Dhanappa Gonki versus the state of Bombay. This matter pertains to Section 161 of the Indian Penal Code. Delay in trapping accused, the fact that nothing is done for a long time between the allies offered to bribe and the actual trapping of the accused does not suggest that the story is false. The police authorities have perforce to wait until the accused make a further move in the matter. It is not reasonable to suggest that the police authorities should go out of their way and actively invite bribes in order to trap the accused. That was a matter lastly appeared by Dr. Babasaheb, and which was appeared before the Honorable Apex Court. After going through all these matters, what we found that there are all sections. Either it's a code of civil procedure, either it's a code of criminal procedure, it's the Indian Evidence Act, Hindu law, Trade Union Act, Maintenance Act, all others, Municipal Act, Abkari Act, taxation. There are all, so far as wherever there is a law and when there is a matter, Dr. Babasaheb appeared in those matters, though he was very active in the politics. He has also, we say that he's the father of the Constitution, and who was the chairman of the drafting committee of the Constitution. But being as a lawyer, we forget his contribution towards our judicial system. And fortunately, the Supreme Court published this 29 judgments which were reported in the various journals wherein Dr. Babasaheb Ambedkar appeared as a lawyer, either for the petitioner or for the respondents. And we see the contribution towards the judicial system. Dr. Babasaheb Ambedkar was also offered that time. They are offered being a judge of the district courts with an assurance that within the 3 years he was elected as the high judge of Honorable High Court. But he refused to do so. He says that being a lawyer is an such thing that I can appear for the downtrodden peoples. And so it gives me a strength and a power. And every time it gives me energy to appear for those persons. The author and the lawyer Rohit Day in his essay, Lawyering as a Politics, devote a substantial portion of the years of Dr. Babasaheb Ambedkar as a lawyer and his choice of practice. He goes to say that his cases were low in volume and value in the 1920s, and he became a law professor in order to sustain a steady income. The contrast come out of a stocky in a newspaper article that report that Jinnah, representing as an insolvency matter of rupees 2,57,000 on the same day, Dr. Ambedkar represented a retired Muslim school teacher in a breach of trust case valued of rupees 24. So this shows that the commitment towards the society, the commitment towards the persons who are voiceless to become the voice and being a lawyer. I thank all the authorities of the MP Law College. Of course, Dr. More sir requested me to deliver a lecture. I was a little bit in dilemma because I had to attend one law college function at Nandurbar and one legal literacy camp at in a tribal area of Nandurbar. One Pada is there, and so I'm in a little bit dilemma. But fortunately, Dr. Rao sir came to rescue me. And he commanded me to you have to come and deliver a lecture on this. And so, being a fatherly figure, I have no other choice to come and deliver a lecture. I'm sorry, there are some technical issues arose while joining this lecture. And I'm very thankful that on this eve of name exchange of the Marathwada University as a Dr. Babasaheb Ambedkar Marathwada University, and when we are celebrating 100 years of starting practice of Dr. Babasaheb Ambedkar as a lawyer, we have a chance to share my views of the contribution of Dr. Babasaheb Ambedkar in being a lawyer in this judicial system. And I'm thanking all the dignitaries and all my student friends who joined this lecture. Thank you.
Thank you. Thank you so much, sir, for sharing all that bit of knowledge. We really had no idea that Dr. Babasaheb Ambedkar had appeared in so many cases that were reported. Thank you so much for sharing this knowledge. I now request our respected IQAC coordinator, Dr. Aparna ma'am, to kindly give a presidential address. Over to you, ma'am.
A very good morning to everyone. Let me thank the organizers, especially the principal sir, who has directed me to give the presidential address. Due to some urgent works, principal sir is not there, and hence the duty has been casted on me. Let me first of all wish we all the best on this University Name Extension Day. We very proudly say, and we feel proud that our university has been now named since last 30 years, of course, as Dr. Babasaheb Ambedkar Marathwada University. The title itself is indicative that each person, each stakeholder of the university is duty bound and is obliged to perform the tasks that are handed over to each one with judiciously, consciously, vigilantly, so that we would protect the name that would be that is given to our university, that is Dr. Babasaheb Ambedkar Marathwada University. Though our resource person, today's resource person, Girase sir, has in his concluding remarks provided you the insights about what all he has covered, but I feel really very happy that during the whole lecture, Advocate Girase sir has very nicely elaborated the cases of Dr. Babasaheb Ambedkar in which he had appeared from 1926 till 1953. See the long journey as a professional advocate. That is their record, that too is recorded on the Supreme Court website, and he has narrated every minute detail about the cases, that too not only the Bombay High Court but Calcutta High Court cases. And if we just look at the canvas which sir has covered, the areas and arenas in which Babasaheb had appeared as an advocate, that include Workmen's Compensation Act, that is almost all the labor laws, one may say in nutshell, civil laws, including Transfer of Property Act, Succession Act, maybe to a great extent even prevention of prostitution. References sir has placed jurisdictional issues and civil procedure code, evidence, and even some cases which sir has referred to are pertaining to the intermediary system and the practices those were prevalent those times. Apart from this, even cases pertaining to the sureties, mortgage, why we need to understand the whole canvas? Because we understand, the society understands Babasaheb as a person who has contributed a lot for structurizing our Constitution of India. But beyond that, as a legal luminary, how Babasaheb was devotedly, wholeheartedly was practicing for the for helping the poor and needy, whoever comes to him, how fairly he has appeared before the court, and what was the outcome of the same. Very nicely, aptly, Advocate Girase sir has rather illustrated before all of us. Sir, you have spent your time, but we feel little maybe inconvenience is caused because of the strength. Looking at the strength of today's event, let me tell you that today actually the examinations are going on, university examinations, and regular lectures are not actually started for the second sem. That might have hampered the attendance, but we will make it sure that if the lecture is recorded, we will make it available to all, because this lecture provides a great insight about a person who was actually involved in the overall development of the nation, how as an advocate he had appeared before the court, creating an insight. Rather, it would be helpful for creating an insight amongst our students that what all is expected from them. One, because we are law students. Second, because we are the stakeholders of the university, Dr. Babasaheb Ambedkar Marathwada University, to which we are affiliated. And being a law person, we need to understand, rather the students, we need to understand how studious we are required to, how argumentative skills are required to be developed amongst students. So there were certain references, those were placed by Advocate Girase sir, in which there were certain twisting points, there were certain turning points. So if the students inculcate the skills, argumentative skills, along with the studies, their whole case may be a turning point, or rather that may turn to be fruitful, or rather that may be providing the expected outcome to the clients. So for that we need to work. Further, sir, in your lecture, you also had referred to the expressions which were made by Babasaheb saying no to the judicial post. because he was more interested, he was more keen in providing the assistance needy to the needy and poor people. My dear students, we need to take a note that we are walking on the path that has been shown by Dr. Babasaheb Ambedkar. May you join the judiciary, may you stay in the practice, may you go everywhere. We have to be very keen about providing justice to the society. Okay, so again, the feeling pertaining to the feeling pertaining to the providing helping hand to the poor and needy also has been inculcated through your lecture. And for that, certainly we, the management staff, and on behalf of even students, we must thank you, sir. It would be great if we could have an interaction in a physical mode in coming time, not only on this area, but practicing law before the court. That would be of really immense help. And on behalf of, or as directed by sir, I am communicating it to you. We are requesting you to be there in our college and continue guiding our students in future academic endeavors too. I once again thank the organizers for giving me this opportunity to give the presidential note. And I thank everyone for being present for this event, and wish you all the best for your academic and research endeavors. Thank you. Jai Hind. Over to you, Mihir.
Thank you. Thank you so much, ma'am. As it is now the concluding part of today's program, I would now like to propose a vote of thanks. At the very outset, I thank our chief guest, Honorable Advocate Girase sir, for gracing us with his presence. I thank our respected principal, Dr. C.M. Rao sir, for his constant support and guidance. Further, I thank our vice principal, S.N. More sir, IQAC coordinator, Dr. Aparna ma'am, our coordinator of this event, Dr. Jadhav sir, and all the teaching faculty as well as the technical support staff who has made this program a huge success today. I also thank all the participants for their patient listening, and with the permissions of the dignitary, I would now like to conclude this program. Thank you all.
Thank you, sir Girase, very much.
Thank you. Bye-bye.
Sir.
Thank you, sir. Thank you so much.
Thank you, ma'am. Thank you, ma'am.